I'd like to extend special thanks to the Review of Banking and Financial Law and to the graduate program and to the Boston Bar Association for co-sponsoring this event along with the Center for Finance, Law, and Policy, which many of you know is a new initiative here at Boston University designed to bring together all of the intellectual capital, if I can be so arrogant as to use that term, devoted to the study of finance. And there is a considerable amount of that. I have the distinct honor today to introduce you to Daniel Hawke. And I want to say that I am bursting with pride on two counts. And I have to confess to that pride, although can I confess to the pride without admitting or denying the underlying sins that go along with it? Dan's father, John Jerry Hawke, is a current director of the center and the former chair of our board of directors for many, many years. He's also the former comptroller of the currency, former undersecretary of the Treasury, a distinguished Boston lawyer, and a revered member of the legal community. You know, they say that people complain that there haven't been enough heads to roll as a result of the financial crisis, not enough prosecutions, not enough convictions. And to a degree, they're right. However, when they say that, they're not talking about insider trading, because in that area, you can only say that the SEC and certain U.S. attorneys have been nothing short of aggressive and persistent. I think the current number is 60 convictions, and one gentleman is now serving the longest term that was ever meted out for insider trading. And many of these predicate offenses go back to before the crisis, but one thing is certain, that if we are going to go forward from the crisis, confidence in our markets, confidence in our democratic capitalist system depends upon the rooting out of insider trading. The alternative, of course, is to say that there is no such thing as transparency, and it's just a Wild West market, and we then would have an entirely different system. Dan Hawke is at the forefront of that effort. He has two jobs. One is as the regional director of the Philadelphia SEC office, which includes among its states not only Pennsylvania but Delaware. So I think it's a full-time. You had a full-time job before this opportunity came along. But then he's the head, and that's why we're here today, of the unit on market abuse within the enforcement division of the SEC. Dan is we're proud to say, is a BU Law alum, class of 1989, and we're also proud to say that his boss at the SEC, Robert Khuzami, is also a BU Law alum. I don't know his class offhand, maybe you do. 85, so he's an old timer. But it does make us extremely proud to have you two gentlemen, you particular Dan, in that critical role at the SEC. So without further delay, let me give you Dan Hawke, and we're going to have his presentation, and we'll be passing a mic for anybody that has questions, so be formulating them now. Don't expect to drive any plea bargains by asking questions on behalf of any of your clients or particular cases that Dan may be working on. Dan?
Just take a second to get set up here. So thank you, Con, for that very, very nice introduction. You know, my roots with BU and the what I guess was known as the Moran Center go back to when I was actually in college in the early 1980s. My father began teaching at BU and got me interested. BU was the only law school that I applied to. I knew I wanted to come here, and it was really the most significant event in my education, coming to BU and learning how to be a lawyer. I want to thank Con Hurley for his invitation to come, the BU Center for Finance, Law, and Policy, the graduate program in Banking and Financial Law, with which I've known since I was a very young person, the review of Banking and Financial Law, and I also want to thank Norm Nickel, my colleague from the SEC's Boston Regional Office, for his role in helping to facilitate this, this presentation today. I'm very, very privileged to be here. When I entered BU Law, I was 23 years old, and it's been 23 years since I graduated. So as I was telling Lorraine Kaplan, that in another 23 years, I plan to come back and talk about the next part of my career. But I do think that perspective, and I can't really believe that it's been that long, but it's been an extraordinary time, and my training and education at BU has served me very, very well. My topic today is the Market Abuse Unit as a response to the call for specialization in federal securities law enforcement. And before I begin, I need to issue a disclaimer that we all are required to at the SEC, that the views that I express today are my own and don't necessarily reflect the views of any commissioner or the commission or any member of the staff. And that disclaimer is particularly important today because I am going to offer my opinions and my views about things, and they're just my views. They may or may not be, accurate, and you may or may not agree with them, but I think, the goal is to make this interesting and informational. So I entered BU Law in 1986, and it was at the heart of the insider trading scandals of the 1980s. The Dennis Levine, Ivan Boesky, Michael Milken, Drexel Burnham cases were all in various stages of having been brought. Insider trading was becoming rooted in the mainstream of public consciousness. There was a front page story on Time magazine about insider trading at the heart of the markets, and the efforts of the government to crack down on it. And the view back then was that that those efforts were very successful, and those cases to this day remain some of the biggest and most complex insider trading cases ever brought. And this is the moment in which insider trading itself entered the public consciousness. The 1980s, it resulted in the passage of the Insider Trading Sanctions Act, the Insider Trading and Securities Fraud Enforcement Act, called Fcpa. And there was a significant amount of attention paid to the role that insider trading played in undermining investor confidence, in destroying the sense that the markets are level and that it's a level playing field for retail investors. And those cases also involved securities industry professionals. Drexel Burnham was an investment banking firm. There were licensed people. And most of law enforcement in the federal securities realm at the time depended on concepts involving the access theory or the gatekeeper theory, the idea that securities industry professionals, that the markets police themselves, that they work best when they're policed by themselves, but you need the steady hand and consistent hand of the government behind it, but you don't want the government too involved in that process. And the notion that securities industry professionals, people who are trained and licensed and who knew better, were caught up in these extraordinary schemes was very, very troubling at the time and resulted in significant regulatory reform at the time. But by today's standards, the insider trading schemes back then were quaint. There were no cell phones. There was no internet, obviously. There was no electronic trading as we've come to know it. There were no online brokerage accounts. Surveillance at the exchanges was done in a much less sophisticated way, pretty much by matching up zip codes with trading records and looking for patterns of people who might be proximately located to public company issuers where the information was likely to be being obtained. So the idea that people would communicate the way they do today, back then it just wasn't the case. It was landlines and very considerably slower modes of communication. In the 1980s, were also a time of budget cuts at the SEC during the Reagan administration. And one of the things that the SEC did was had proposed a plan to conduct active real-time surveillance of the markets. And it had planned an office or a capability that would enable it to obtain direct access to real-time trading data. And due to the budget cuts that were across the government, every agency was required to, I think it was 10%, required to reduce their budgets by. The SEC, one of the casualties of those cuts was this idea that the SEC would conduct its own real-time market surveillance. And that's very significant because what that did is it put the commission in a position where instead of having an offensive surveillance capability, it was really effectively placed in a very reactive mode. And so those plans were scrapped, and the result was rules that basically required the exchanges and the self-regulatory organizations that govern the exchanges to conduct their own surveillance and to report when they found suspicious trading to the SEC so it could investigate. And of course, this reactive posture meant that the SEC would act when information was brought to it, but was really not in a position to compel direct real-time market data as trading was happening, which I think from an enforcement perspective is probably not what the public thinks is actually going on. I think most people see the movies. I think in it was Wall Street or in various movies. We have windbreakers that say SEC on the back. We don't. We have motorboats and helicopters that say SEC on them. We don't. We carry guns, and we definitely don't. And you don't want us to. But there were lots of implications to this idea that the SEC, as a law enforcement agency, was really very reactive in its approach. And there are lots of ways that the SEC gets information from about potential securities law violations. We get tips from the public. We are scrupulous readers of all the industry press and media that governs conduct that reports on conduct that we see. We have a very robust relationship with the industry press and the media because oftentimes it's journalists who will identify suspicious conduct or problematic trading and write a story about it, and we'll pick it up from there. We have our inspection and examination program. We have a financial and reporting and disclosure through CorpFin and through the Securities Acts and the Exchange Act reporting requirements. And then we have SRO referrals, which are trading referrals of suspicious or aberrational trading that the exchanges generate as a result of their surveillance activities. And what's important to understand is that this entire process that I've described is issuer-based or security-based. If a reporter writes a story that, say, for example, Intel to acquire IBM, we would open an investigation if we thought there might be suspicious trading in IBM stock. And so you would begin with IBM as the issuer, and you would say, well, who traded in IBM stock? And it's a very limiting, very narrow perspective because you're really only focused on trading in IBM because you're starting with that fundamental question. It's the issuer whose stock is being traded. But the conduct is occurring not by IBM, it's occurring by people who are trading IBM stock. In many respects, IBM and its shareholders are the victim of the trading. So there's this sort of fundamental question of, when you have an issuer-based or security-based approach to beginning your investigative process, what are the implications of that? And when you combine that with a reactive mode, then it becomes very clear that you're going to look at things in a way that are naturally engineered towards a narrower perspective. And that approach has served the SEC very well over many, many years. I mean, the agency is a relatively small agency, roughly 3,000 to 4,000 staff. There have been times where the entire enforcement division has been smaller than the legal departments of one investment bank. So when you think of the mandate that we have and the amount of money that we're responsible for policing, the resources that we have are extremely limited. And really in some respects, the SEC's reputation over history has been built upon creating public expectations that it is mightier and more capable than its resources and its abilities really may actually be. And this begs the whole question of resource allocation and budget, and I'm not going to get into those issues, but the notion that we have to do a better job with the resources that we have becomes relevant to the story that I'm going to tell you. So, basically the staff would determine the security issue and then ask who traded. And that's how many investigations began. And we'll come back to this idea of a security-based approach versus a trader-based approach in a few minutes. As you all know, the market crisis that unfolded in 2008 unfolded over a period of months between the spring and fall of 2008. The markers that I put down are really the collapse of Bear Stearns in around March of 2008, and then the collapse of Lehman, I think on September 15th of 2008, where the role of hedge funds, the role of credit default swaps, the securitization of mortgages and mortgage-backed securities, the level of systemic risk, the role of regulatory policy, the societal values and attitudes towards credit and risk all become implicated in people's efforts to try to understand what caused the market crisis. And certainly the SEC's role and a role as a disclosure-based, the doctrinal foundation of the SEC's statutes are that they are disclosure-based, that they are intended to put the burden on the industry to police itself, but through disclosure. The view that investors, if they have the information, if they understand what they're buying and selling, and counterparties having information about the people with whom they're engaged in business, will be able to make the best decisions. And that the role of the SEC with its enforcement power is there to step in and to hold people accountable when that self-policing and when that access and gatekeeping function fails. And there were no doubt, there were warning signs in the crisis. As early as June of 2007, there were 2 Bear Stearns hedge funds that were shut down as the result of questionable trades and practices that ended up being very much the canary in the coal mine as to what was coming. And during that period, between the spring and fall of 2008, you had the Commission issuing an emergency order on short selling, restricting naked short selling in the securities of financial institutions. And that emergency order, when it went into place, provoked debates about the uptick rule, about the role that naked short selling plays. Naked short selling, there's nothing inherently illegal about it, as long as at the time the rule for delivery requirements of the shares being sold were complied with. But there were strong suspicions that short selling was contributing to the volatility in the market and were exacerbating the impact that the economic downturn was having, particularly on financial institutions. So with the SEC being in a very reactive mode during this period, it's not surprising. I mean, as I've mentioned, that the SEC administers a disclosure-based statutory scheme, and it was not set up to police every fraud or to detect every violation. We're not staffed that way, we're not funded that way, and our statutes and rules don't permit that. And there was a question as to whether or not the practices giving rise to the market crisis were based on poor risk management, or whether they resulted from violative conduct. And as we've seen, the answer isn't an either or a response. It's both, and it's probably more than that. There are many, many reasons why the market crisis occurred. But there was a clear need for regulatory reform and a clear need for the SEC to define, or for people to debate what the role of the SEC was, whether a disclosure-based system is working, whether the statutes that we administer need to be updated, and whether our processes, our structure, and the way we use our resources need to be reallocated. And those were all legitimate questions for debate. And there was a lot of blame to go around in the industry, in the public, in the regulators. No question that there was blame to go around. But then comes the Madoff case in December of 2008. And I'm not going to get into the details, but I think it's fair to say that the SEC missed that case. There were multiple complaints, including actually from a resident of Boston, alleging that Madoff's business was a Ponzi scheme. And the staff had those complaints, and the staff understood what those complaints were, but they focused on the wrong issues. And there were numerous failures. There were management failures, there were supervisory failures, there were staff failures, there were cultural failures within the SEC. And really, a Ponzi scheme on the spectrum of frauds is relatively simple in its operation. It's not, they can range in complexity, but the basic idea that you're taking one person's money and you're effectively giving it to somebody else is not that difficult a concept. Now, how you audit that, how you investigate it, the way that conduct is dressed up to make it appear that it might be something else is a different question. It's also the case that there was extreme deception involved, and that people, that everything we look at entails some element of deception. There's not a fact that comes to our attention where you don't have in the back of your mind the idea that the person you're investigating or the person who's telling you the story may not be telling you the truth. So the concept that it's possible that the SEC was deceived is a view that I don't think has gotten a lot of attention in the effort to sort of identify responsibility. But it's no doubt an element that governs the daily lives of our exam staff, of our enforcement staff, and the skepticism that they have to bring, and the incredible pressure and responsibility that they have to deal with facts as they unfold in front of them. And the criticism resulting from Madoff was withering. I mean, anybody who was at the agency at the time knows that it was not fun to be reading about these failures and recognizing the impact that they had on the public. I think that the SEC staff in their own quiet way was devastated by the impact that those failures had. It's the last thing that the staff would ever want to see happen. It's antithetical to our mission, and yet we had to come to grips with what it represented and what it meant. So there were calls for specialization, this idea that we didn't understand what we were looking at, and we didn't act right when we did understand it. We didn't make the right decisions, and that we needed a more specialized approach. We had too many attorneys and we had too many accountants. We didn't have enough industry experts was one of the refrains that we heard. That we need to develop a better understanding of the securities markets, and of course that we needed to reform the SEC's processes. When Chairman Shapiro came in and Rob Kazami, my boss, they promised reform, they promised restructuring and streamlining, and they promised specialization. And I'm going to take a step back from their calls for specialization and now talk a little bit about the market abuse unit and how, and then I'll pull it together for you so you understand how the call for specialization ties to what I do and why I'm here today. So I had been a staff attorney in the home office. I'd been in private practice for 10 years, and I decided that public service was what I wanted to do. And in 2000, I joined the SEC in 1999 as a staff attorney, Loved it. They handed me the Arthur Andersen Waste Management financial fraud restatement. It said, go figure it out. And it was great lesson in landfill accounting and how to value garbage trucks after they've run for 10 years. At Waste Management, their garbage trucks became more valuable the longer they ran them. So one thing I learned, like the 32-day month that some companies use. But I had developed a number of cases in the home office in Washington and become a branch chief, and I was offered the opportunity to go to Philadelphia to help run the enforcement program there. And one of our earliest cases was a case that we got as a result of a tip that a woman in Washington State had sent to me, saying that there's a spike in volume in a company called In-Kind Pharmaceuticals, a very obscure pharmaceutical company. And she had noticed at the close of trading a spike in trading. A very relatively low volume security, relatively relatively unknown issuer, but she didn't know what accounted for the spike in volume. All she saw was that there was trading activity before an announcement that a company called Salix Pharmaceuticals was going to acquire In-Kind. So we opened an investigation, and we spent months trying to figure out, who was behind the trading. We have the ability to obtain what's called blue sheet data, which is, every securities trade that is placed leaves a marker through the clearing firms that it passes, in terms of the name of the account that traded it, the location where the account exists, a host of information about address and intermediary firms that it may have been passed through. And we began to look, and we found that the account in which the volume of trading in In-Kind came back to an account in Tallinn, Estonia. But at that point, we still didn't have a good explanation. And again, this is a trader-based approach. We've got a tip about a company called In-Kind, and we're looking to see who traded it. And what we began to piece together was a pattern of trading where this account was trading in front of hundreds of public company press releases involving, I think there were 300 press releases issued by 280 public companies, where this account had successfully traded almost every time, either making a profit or avoiding a loss, and usually in minutes, seconds, minutes, or hours before the announcement. And the question was, well, what's the common link? How is this, does this person know somebody at all these companies? Probably not. That's too inefficient. Is there somebody in the chain of information that might be tipping information? Probably not. That's too, a tip by itself is going to take too long to communicate. The speed with which these trades were being placed was too fast. So we found the least common denominator was that all of the press releases had been issued through a commercial newswire called Business Wire, which is the largest disseminator of commercial press releases in the world. We, by this time, had identified the account and the broker-dealer at which the account was held, and that broker-dealer was a U.S. online broker-dealer who we engaged surreptitiously, and were able to determine that all the trading was passing through a master account of an Estonian broker-dealer called Lomas Havel and Weisman. And the trading was remarkably successful. Up to $30 million of trades had been placed. At least 15 million were related directly to issuers whose press releases had been issued through Business Wire. And we also knew from the online brokerage account what computer was accessing the account. Every time a computer accesses a brokerage account, it leaves a marker in the form of an IP address, and we were able to see the computer identification through the IP address, Internet Protocol address, coming back to computers in Tallinn, Estonia. But in order to make out a cause of action under Section 10B, we needed to connect the trading in the account. We have an in connection with requirement with the purchase or sale of a security to some sort of deception or theft of information. Insider trading under common law requires that you show deception, and the way that the courts have established deception in the context of insider trading is by finding the existence of a breach of duty. So we had to, in order to state a cause of action, we could see all this incredibly successful trading. We have tens of millions of dollars sitting in a U.S. brokerage account. We think we understand how the scheme is happening, but we don't have enough evidence to close that evidentiary gap between, is the person doing the trading the same person who's stealing the information? And that required a level of investigative effort that becomes quite intense. So we go to Business Wire and we say, we think there's some suspicious trading. Look at all these trades. And they look at it and they say, fair enough, we are a disseminator of business information. We have certain First Amendment protections. We're happy to help you, but we need a subpoena. And this process took several weeks, months to get them to accept the idea that there might be information coming from their systems that was being used to place these trades. So we issued a subpoena, and we requested that they identify any places where their servers had been accessed by a computer matching the address that we had gotten from the broker-dealer. And after months of back and forth, within a couple hours of getting the subpoena, they ran the IP addresses against their servers and found the same IP address. So now we had the person who was doing the trading inside of Business Wire. But they weren't hacking into Business Wire. They had opened an account. So they were actually coming in through the front door. And they had sent this young man named Oliver Peak, he was 24 years old, developed a program called a Spider program that basically he would launch his connection to Business Wire, go in, the Spider would look for press releases in the queue ready to be released, would see the file name of the press release, but not the press release itself. And that file name, a lot of times, unless it was written in a code or it was otherwise disguised to conceal what the substance of the release was, usually had enough information to allow somebody to position a profitable trade, which is what Oliver Peak did over and over again. When we filed, that case was filed on November 1st of 2005, and it really opened my eyes to this idea that this guy, sitting at his desk, in a matter of seconds, could steal information and place a trade in such small amounts that it would be very difficult for a typical surveillance algorithm to pick up. But it's like stealing a penny from the bank every day. He was able to get in and get out, and really in a very undetectable way. And our informant in Washington was a market observer. She had no idea what was going on, but she knew enough to know that spike in volume shouldn't be there on the in-kind announcement. So we bring that case, and it gets a little attention, and I think certainly within the agency we're very proud of it, but it took a while before people began to realize that, wait a minute, this is not a typical investigation, and understanding how the markets work, how the speed with which trades occur, the speed with which information can be stolen and utilized became very significant. There were two other cases, a case called Wang and Chen that we filed in Wang and Chen in 2006-2007. We noticed trading in front of a number of Morgan Stanley deals. And the trading appeared to be coming out of a brokerage account at ING, and in Beijing, China. And we weren't able to, there was no obvious connection between the person doing the trading and Morgan Stanley. As we began to investigate, we again looked for internet protocol addresses, and we found trading in brokerage accounts from servers located in New Jersey. And they came back to a man named Wang Chen, who was an analyst at ING. And as we began to dig, and of course, again, in both these situations, the money's in the accounts. And the minute that those people know that we're looking, that money goes. So all of this is being done covertly, and it's being done extremely quickly and carefully in order to try to find, get to the money before it can go offshore. Once that happens, then it's not that we're divested of jurisdiction, but the ability to prevent the proceeds from going offshore is the priority. And we began to look for a connection between Wang Chen and Morgan Stanley. And it didn't take long, but ultimately determined that his wife, Jennifer Wang, worked at Morgan Stanley as a vice president in one of their groups. But again, we had to establish that there was a connection. One helpful piece of information that we had was that one of the trades that Wang Chen placed we only had vague server information from New Jersey, so it was still unclear that he was the one behind the account, behind the trading. But we found trading that came into one of the ING accounts where the trades were initiated out of the Four Seasons Hotel in it's either Seattle, Washington, or Portland, Oregon. And we were able to place Wang Chen in one of those hotels on the night that those trades were placed. So once we had him locked down, we knew that if we could establish a connection between him and Morgan Stanley, we would likely find the source of the information. And it did not take a whole lot of work at that point to then identify Jennifer Wang as a VP at Morgan Stanley. But then we had to figure out how was she getting access to the files, and how did she know what deals were being worked on and where to look. And we conducted a very intense forensic analysis of the folders that she accessed, the permissions, whether or not her computer had access to the drives and directories on Morgan Stanley's computers, and whether or not in real time we could establish that she was actually the one accessing those files. And ultimately, we were able to, through forensic analysis, able to get that information. And the last case that I'm going to mention actually also involves Morgan Stanley, but this time not so much as victim or employer, but as perpetrator, where Morgan, we had noticed that in December of 2006, Sirius Radio had announced that they had retained Howard Stern as to be one of their sort of lead hosts or personalities for Sirius Radio. And Morgan Stanley realized a $6 million profit on trading in Sirius satellite radio that day. And the question was, and the staff was conducting a sweep of broker-dealers around the country to look for best execution violations, order routing violations, places where trades might not be getting the best price depending on where and when they were placed. And Morgan self-reported this $6 million aberrational profit because they were alarmed as well. So we began to look into it. And as we looked, we found that there was computer code in Morgan Stanley systems that enabled the firm's desk to capture the spread between what's called the National Best Bid or Offer, the NBBO, and the execution price associated with that particular trade. And in the actual computer code of the algorithms that run the Morgan trading platform that was at issue, in plain English were the words capture spread. Somebody had programmed into their trading algorithms this command that was described as capture spread. Well, of course, they're not entitled to capture the spread. They're obligated to give their customer the best price. And they were effectively capturing the difference between the price that they were getting and the best bid or offer for themselves. And what made the case a fraud case was that compliance people at Morgan had noticed the computer code and had told the business people to take it out. And they did. And that was the right thing to do, and if that had been the end of this story, we probably wouldn't have brought an enforcement action. But somehow the code got put back in, and when the Sirius satellite announcement came out, and there was this surge in trading interest, that capture spread grabbed $6 million worth of profits for Morgan from its customers that it wasn't entitled to. And Morgan self-reported, and there began our investigation. But what these three matters did for me and for my office was to heighten our awareness that when you have systemic type issues, when you have trading, platform type issues, when you have electronic trading and communications issues, that the methods that we needed to adopt were, or that we had been using, were way, way out of date in terms of our understanding of how to investigate securities fraud, how to do it in a way that would be effective and ensure that money is protected, that systems are protected. And I think most staff attorneys who came into the SEC were given training on how to conduct insider trading investigations that by today's standards was probably 10 or 20 or 30 years outdated. Certainly would not have allowed you to find the types of violations that we were finding in these three cases. So back to Mary Shapiro and Rob Kazami. They come in and they promise specialization and they promise reform. And I was, as the director of the Philadelphia office, very involved in Rob's senior leadership to help implement the various structural and process changes that he was adopting. And the question came up, what should the specialty units be? And there are 5 units. There's an asset management unit, which specializes in 40 Act type violations, hedge fund compliance, private equity, mutual fund compliance, and a whole range of valuation, trading, range of securities compliance issues that apply in the 40 Act area. There was the Structured and New Products Unit, and this was in response to the idea that many of the credit default swaps, the mortgage-backed securities, a lot of the exotic derivative products that had been developed, that our learning curve had just not kept pace with the innovation and development of products that was occurring on Wall Street, and we needed to do a better job of that. There was the Fcpa unit with the Foreign Corrupt Practices Act, which actually harkens back to the Division of Enforcement's origins during the questionable payments cases in the 1970s, where foreign companies, U.S. companies would pay bribes to foreign governments to get business, and the question of how to attack that problem from a securities law enforcement perspective was developed, ultimately resulting in the Fcpa. We've always considered that sort of a bread and butter area for the SEC. And then the other unit was the Municipal Securities and Public Pensions Unit, which is led out of my office in Philadelphia, and that was in recognition of the complexity of the market, the municipal securities markets, the complexity of public pension funds, and the vast amounts of money that are implicated in those two areas. But for market abuse, the question is, what is it, and why do we need it? And what is our mission? So when we get the call, and the question Rob has is, okay, so why a market abuse unit? I had, against this backdrop, this prior 5 years of experience looking at all these cases that seemed very elusive to me in terms of my understanding, our resources, the way our workflow was engineered. And we had been working on a case at the time involving an investment banker at UBS named Nikos Stefano. And Nikos was working on a deal involving the Albertsons supermarket chain that was about to be acquired. This was in late 2006, early 2007. And as we were doing our surveillance in that case, we were getting blue sheet data and we were analyzing it. We realized that we have decades of blue sheet data that where, as a result of the budget cuts in the 1980s, we were obligated to go to the SROs when they sent us referrals and ask them to send us trading data. And clearing firms send us trading data that we could analyze. All that data was stored in our servers. And we began to look for ways to query that data, to figure out how we could look across, millions and millions, hundreds of millions of trading records to try to look for patterns of conduct or trading. And what we began to realize in the context of the Nico Stefano investigation was the idea that this issuer-based approach had served the division very well and very effectively, but that in order to enhance our enforcement activity, a trader-based approach would be very valuable. And that trader-based approach basically says that rather than look at the security and ask who traded it, start by asking who's trading and what securities are common to them. So under the issuer-based approach, you start with the security and you're necessarily limited to who's trading it. You might be able to develop leads that take you other places, but your initial query is based on the issuer. The trader-based approach starts with who traded and asks, okay, well, what securities are common to them? In an insider trading case, we really don't care, and nor do the traders, anything about the company. I mean, it's based on material non-public information. They're not investing in the company because they think it's a good company. They're investing in the company because they've got information that they know is going to move the market, and they want to profit from it. And so the issuers in an insider trading investigation are fungible. They may be where the source of the information is ultimately, but their conduct really isn't at issue. It's the trader conduct that's at issue. So we began to develop an approach to conducting trader-based analyses of conduct. And what that enabled us to do was to reorient our workflow and our investigative approach to figure out patterns of trading, relationships, make connections between people in a very proactive, offensive way. And this approach resulted in the filing of a case against Nico Stefano and 5 other people involving their trading in Albertson stock. And we were able, through this type of automated blue sheet analysis, to piece together all of the relationships among each of the traders concerning how they knew each other based solely on how they traded. And to do it very quickly and do it very covertly in a way that allowed us to attack the problem. And Nico Stefano, this was December of 2008 at the time, so the Madoff case had been revealed a few weeks earlier. We got information that Nico Stefano was in Mexico with his fiancée. He lived in London, and he was coming back through the United States and would be stopping in Newark Airport. We took our trading data and our analysis, and we went to our colleagues in the Southern District of New York. And the FBI met Mr. Stefano on a stopover in Newark, escorted him off the airplane, let his fiancée continue her journey without him, and thereafter spent the next 2.5 years incarcerated in the Manhattan Correctional Facility. Nikos ultimately cooperated with the government and testified, including at the trial of Joseph Contarinus, who was a hedge fund manager at the Paragon Jeffries firm. And Mr. Contarinus was convicted in October 2010, is sentenced to 6 years in prison and $7 million worth of trading profits. The SEC just yesterday, 2 days ago, got a judgment from the Southern District for his disgorgement, his $1 million penalty, and a permanent injunction. But that case, the Nico Stefano case, was really the evidence that this idea of a trader-based approach would work. And at the time, we issued a press release, and we called them novel investigative strategies. And there are aspects of it that we won't discuss, but that it's important for the world to understand that we are being very proactive and changing our way. So let me just go through just quickly, and I don't know how much more time we have, but let me just a couple minutes. Okay. So the unit gets formed in January of 2010, and I'm selected for the unit chief position, and there really wasn't a model in place for what we were going to do. We knew that we needed to be proactive, and we had this idea behind the trading strategy, but our focus was really on institutionalized insider trading, organized or network insider trading, and we had some reference to systemic or platform-driven violations, but nothing really more than that. We have staff in 8 different regional offices, including here in Boston, 50 lawyers around the country who are in the unit, and 6 industry specialists. And these specialists range from trading strategy specialists to quantitative analysts to high-frequency trading specialists, market operations specialists. And those people were hired into the unit in response to the call for more industry expertise. So the story basically, you would think, ends there, where we are responding to this call for a specialized approach, that we have recognized the need for it, that we've got to do a better job, and the unit becomes fully staffed in April of 2010, and 2 weeks later, the market break happens, a flash crash. And at that point, it becomes clear to us that this is exactly what the market abuse unit was intended to address, that the ability to, you cannot hope to know how to conduct an effective law enforcement investigation of the markets if you don't understand how those markets are structured, if you don't know how they work, if you're not fully conversant in the practices, the processes, the systems that they involve, particularly given the fragmentation of the markets that had resulted from the adoption of Reg NMS. Instead of there being 2 or 3 securities exchanges, there are now dozens of securities exchanges where I think the general New York Stock Exchange accounts for maybe 18% of the volume that's traded every day. A substantial amount of the trading that happened on May 6th was occurring through market centers that the average member of the public probably doesn't know exist. The same economic interest in any one particular security can be traded multiple ways, through options trading, through derivatives, through ETFs, through different types of hedging strategies. And if you think you're looking at a particular economic interest that's manifested in a particular type of security, and you don't understand what other types of mechanisms there are by which that economic interest can be exchanged or monetized or capitalized on or borrowed against, then you can't really get a complete picture of the market that you're trying to police. So my unit undertook to learn our market structure and to do it in a way with a highly specialized approach. And the view being that if we could get to a point where we had that level of understanding, we could be very proactive, very offensive-minded, and kind of change this sort of reactive mode into a more proactive mode. So the cases that have resulted in the last 18 months, as we've begun to develop this approach, have been very significant. Although the Galleon cases are being investigated out of the New York regional office, it's the market abuse unit staff that are conducting those investigations. And obviously, as Khan alluded, Raj Rajaratnam was sentenced to one of the, if not the longest sentence of any insider trader in history. As a result of those cases, you've seen the Gupta case that was filed, the expert network cases that are being filed. And of course, those cases implicate very profound questions of, what is considered legitimate research? What is the mosaic theory of non-public information aggregating to become non-material information aggregating to become material information, and can you trade on it? We filed a case called Temple and Pastro, which involved a law firm network security, IT security manager, and an M&A law firm in Delaware who was stealing information about M&A deals that his firm was working on. And we caught him. We picked up the pattern using this relational analysis that I've discussed. We sued an FDA chemist in Washington for stealing information about forthcoming drug approval announcements, where in the course of over 22 or 23 announcements, he had set up nominee accounts, again, separating himself from the accounts, but stealing the information. In that case, we worked with the Department of Health and Human Services Office of Inspector General and had a computer program installed on the chemist's computer because we needed evidence to show that he was actually actively accessing material non-public information about new drug announcements. And what we found, and this computer program sent every 5 seconds, sent back a screenshot showing which file folders he was accessing. And those screenshots enabled us to show, to meet the element of the cause of action, that he was engaged in the theft of, by deception, of information that he wasn't entitled to use to trade for his personal benefit. And that case has had significant implications in connection with this idea of government employees trading on information, including members of Congress trading on information that they acquire in the course of their official duties. We brought a case called Garrett Bauer, which involved an associate at the Wilson Sonsini law firm in New York over the course of 8 M&A deals. And this scheme was particularly pernicious because they had set it up to trade through a middleman, where the middleman stood between the lawyer in the law firm and the trader who was doing the trading. And the middleman and the trader, the source of the information, would give their trading instructions to the trader, but not trade themselves. And through our pattern analysis, they messed up because we saw lots of trading between the middleman and the trader in deals that did not involve Wilson Sonsini. So we knew that they knew each other, but we had no connection between the two of them to anybody at Wilson Sonsini until the middleman decided one day that he wanted to trade in a Wilson Sonsini deal too. And once we had that information, again, using our trading analysis, we were able to reverse engineer the idea that, well, we know they're trading in stocks where there's no connection to Wilson Sonsini, but now they're trading in stock where there is. And that gave the FBI enough information to approach the middleman, flip him, and that was a scheme that went on for 17 years and generated over $37 million in profits. The associate at the law firm worked at 5 different law firms. Wilson Sonsini being the latest one where he was finally revealed. We've brought 2 market structure cases, the direct edge case in October, which was against an SRO for systems violations of Reg NMS, not failing to maintain systems according to requirements for a national securities exchange. And the Alchemy case, Alchemy Ventures case that we brought last week or 2 weeks ago, which was an account intrusion case where the trader hacked into an account either by gaining the password to the account or by figuring out how to get into the account, liquidated all the stocks in the account, and then bought securities where he had already pre-positioned positions in other securities in his own account somewhere else. So what he basically did was, before he hacked in, he goes out, he buys, a stock that is less than desirable, maybe thinly traded, very volatile, loads up on it, and then hacks into the account, liquidates the blue chip securities in that account, and then starts buying up the stock that he's already positioned himself in. And in doing that, he effectively manipulates the market up, sells into the demand that he's created, and then takes the cash out of his own account. That that concept of an account intrusion was well known to us, and we brought a number of those cases, but what was significant about the case was that he used market access provided by unregistered broker-dealers who were otherwise required by the Exchange Act to be registered as broker-dealers, and that the internal controls that a broker-dealer would have would have enabled them to have detected the suspicious trading. So that was a case where if you looked at it as an account intrusion, you would say, well, that's a relatively routine case. But when looked at from a market access standpoint, it becomes a highly specialized case and becomes very significant to our ability to be effective. So that's the story behind the market abuse unit's existence and why it was created and how it addresses the concerns that that the public and others have had about what is the SEC doing to be more proactive and to go on offense and to do a better job of protecting investor interests.
We have microphones for your questions, and it's important that we have you, Mike, because we're videoing this, obviously, and if you don't speak into the mic, then we'll only have the answers and not the questions. I'll take the
Sure.
liberty of asking the first question, and that is, with all the heightened I'm violating my own rule. Jeez. With all of the awareness that your unit has focused on insider trading, as you chronicled, is there any evidence that the market has behaved any better as a result?
I mean, that's hard to say right now. I think that what the insider trading enforcement over the last four years or so has shown was that an alarming number of securities industry professionals were engaged in what we call organized insider trading, where there were literally networks of people who were on each other's speed dials and using disposable cell phones and other mechanisms to communicate, which is really not that different than historically how insider trading has happened. What was significant about it was that so many industry professionals were caught up in it, and that was very alarming because, and they tended to be younger, people who were still, in some instances, children when the insider trading cases of the 1980s were occurring. That the idea that these lessons had to be relearned, that we had to reassert our enforcement presence in that way. I think that cases like the Galleon case and the Expert Network cases and the Nico Stefano case, the Joseph Contarinus case that my office brought, he's going to be in jail for 6 years. He was very, I think he's somebody who got caught up in it, and I mean, it's a tragic story for him personally, but I think for the people around somebody like that, there's no question that that's had an impact. I think the idea when the Southern District of New York used wiretap evidence, that the notion that the government might be listening to conversations, there are very strict rules and due process considerations and privacy considerations that relate to the use of wiretaps. They're not used casually or lightly, but the notion that the government was attacking insider trading the way it attacks organized crime, I think has caused a change in behavior, if anything, to make it more difficult for people to feel comfortable that they can be sharing information without the fear of getting caught. Part of my willingness to speak about some of the things that we're doing is to try to get the message out, because there's an entire compliance apparatus and supervisory regime on Wall Street that pays close attention to these issues. And we can't do it, as I said, with our resource limitations. So part of the goal is to bring cases that change awareness and that have a real impact on the way. For instance, our network security manager in Delaware I'm pretty sure, I don't have any direct evidence of this, but I would imagine that M&A law firms out there who saw themselves similarly situated began that day to ask themselves, well, what are we doing to ensure that our IT people are not potentially misappropriating material non-public information of our clients? So, I mean, we have not noticed, we're not, let me put it this way, we don't have any shortage of work, but we may not know for several years what the impact of these prosecutions and enforcement actions will be.
One quick question.
Sure.
And it's got two legs. There are two legs to it, and it's based on the approach that your unit uses. You talked a lot about computers, and you use a lot of computer science-related terms. So that seems to suggest that you rely heavily on computer-based forensic. With such a level of reliance, I mean, aren't you turning this into a technology war that pretty much describes a reality that resembles very much that of the Red Queen phenomenon, where you have to get up every morning and run faster just to keep up with your target? That's the first leg. Second leg, you also talked about the difference between the trader-based approach and the security-based approach. With the trader-based approach that your unit uses, aren't you turning any successful trader into a suspect that needs to be investigated, pretty much?
There are, let me answer the second question first. With respect to the trader-based approach, there are, the idea is that we can't investigate people without having a reasonable basis for believing that there may be a federal securities law violation. So we're not out there, trying to, find people who we don't otherwise have a reason, that would withstand scrutiny for looking at. The idea that, traders in insider trading cases are the ones who commit the violation. It's not the issuer. The issuer is fungible. It doesn't matter to the person doing the trading that they're trading in any particular issuer stock. It's just the stock at the time that they have the information that they care about. And so I think and given that those trades are occurring through public securities exchanges, through where, on trades where there's no expectation of privacy, that is a legitimate enforcement approach, in the same way that, in my view, when a state trooper is putting a radar gun out, they're looking for people who are potentially speeding. Which leads to the answer to the first question, which is, yes, it is heavily dependent on technology, but right now, what the market break or flash crash showed us was the speed with which trades occur in the market today. They occur in milliseconds, microseconds. They are in the time that it takes to blink your eye, you can have, thousands of trades executed. And what that means is that the method by which we try to approach that type of trading necessarily requires us to overcome the technological gap that exists between the speed with which those trades are happening and our ability to identify them. And when you look at an event like May 6th, where the market in the space of 5 minutes in some, Dow Jones blue chip stocks went from trading at $40 or $50 a share to 1 penny. And then as fast as it went down, came back up. That recognizing the role that technology plays becomes crucial to your ability to be effective in policing. And the analogy that I've used in trying to make the argument for more resources is, it's a little bit like policing a highway where there's no speed limits. Using let's say, pick your old-fashioned Model T, while people are flying by you in Lamborghinis and you can't even see them, they're going so fast. And there's this incredible pressure and expectation on us to say, well, why can't you catch them? And that requires a certain amount of ingenuity and a certain amount of technology. And when I tell you, and my SEC colleagues who are here will confirm that, we need resources because it is completely unrealistic to expect that the type of conduct that can occur when people have the ability to manipulate stocks where they're trading in micro or milliseconds, you could have a manipulation scheme occur in that space of time, but if you can't see it or you don't have the technology or the analytics to be able to get your arms around the volume of trading that's occurring, you can't do it. And I think if you saw how we enter our time at the SEC or record our travel at the SEC, the delay between when I go to put in my time at the end of the week and it says, please be patient, entire frauds could be, committed in that time. So the notion that we are very anti, I think we just upgraded to Windows, Outlook 2003 or something. So we're behind, and I think that there's fair blame, to go around to the SEC in places where it should have done a better job. But if you knew how hard and dedicated the staff is and the way they approach their jobs and the technological obstacles that they have to overcome, the ingenuity, the resourcefulness that they have to call on to be able to attack these kinds of problems, it's extraordinary.
Thanks. You have spoken about the reform initiatives that have taken place internally at the SEC, but in light of the fact that in the US you have so many different regulatory players within the financial industry, do you care to elaborate as to how some reforms that have taken place since the crisis to maybe streamline and make sure that the whole financial industry is regulated more efficiently?
Well, there's, as part of the Dodd-Frank reforms, there's the Financial Stability Oversight Council, which has as its mandate, members, all of the major financial regulators, and a goal of ensuring that systemic risk information is shared among and between each of the regulators. My experience in dealing with our colleagues throughout the banking industry, throughout the CFTC and state and federal criminal and civil regulators and law enforcement is that the approach to sharing information, to cooperating, to making smart decisions about jurisdictional lines that are drawn is very, very good. I think the policy questions about the streamlining of the financial regulators are probably better addressed to my dad. He understands that stuff better than I do. But in terms of the way we police the markets, the cooperation that exists and the coordination and the information sharing, there's an argument to be made that the number of regulators actually gives us wider net and broader coverage and that there's more belt and suspenders. There's also an argument that it's inefficient and that information doesn't flow as well as it should and that it ought to be, and I think the idea behind the FSOC is that it's a forum for managing systemic risk in a way that allows information from each of the regulators to come to a place where it can be managed and disseminated effectively. And we're in the middle of that. I think that time will tell as to how effective we are. On a case like MF Global, which my unit has some involvement in, that's an example of very, very close coordination among regulators and clearly you have a very complex industry with lots of different roles and strategies and products and that don't easily lend themselves to sort of an umbrella approach. And so I do think that there's a role for the agencies that are out there, but as a matter of policy, I don't really have too many views on that.
Well, I was going to say that, to be fair, we have to recognize that the SEC has dealt with a political environment over the last 10, 20 years, which has been determinedly denying you resources. And it's been absolutely disgusting, I think, what's been going on in Congress there. I hope that you are starting to see a little bit of light at the end of that tunnel.
A little bit.
And feel like you actually are going to be able to pay people a proper salary. There was a rule where the SEC people couldn't be paid at the same pay scale as other people at the same GS level. But on the question of what your role would be, a little building on the last comment, we've had all of this derivatives trading, which has been completely no transparency, no regulation, no nothing. Do you have plans as to, or understandings that you're working on as to how the SEC, what role it will have in that as Dodd-Frank goes forward?
Yeah, I mean, there are provisions of Dodd-Frank which require rulemaking in areas involving certain derivative products and structured products. I mean, that are all rulemakings that are underway. And you're right. I mean, the same transparency that prevents an investor or people and the risk managers in the marketplace from having transparency into, counterparty transactions or hedging transactions that they can't see so that they can make intelligent decisions. We have the same problem when we go to investigate. I mean, there's no exchange for those types of products. So trying to get information about, there's no blue sheet system that you can go to say where, who's behind that particular transaction or that particular trade. So, part of the Dodd-Frank reform, proposals is that there be more regulation in those areas to try to require, more disclosure, more transparency, more, the type of, raw data that we currently don't have access to. I think the two things that are most significant are really that I think bring this discussion full circle. The Commission has outstanding right now something called the Consolidated Audit Trail, or CAT, which in the aftermath of the market break, when the flash crash occurred, we had no information about what actually was going on in the market, and we were completely dependent on the SROs to provide us with that data. And the market break team in the market abuse unit was very much involved in understanding, what kind of data should we have had that we didn't have that would have helped us be more effective in the immediate aftermath. You remember at the time, there was this idea that there were possible terrorists, it might be a terrorist event, it might be a fat finger trade, that there might be other reasons. And so trying to get to the bottom of that quickly, it's a combination of, if you adopt a new rule that requires certain reporting and disclosure, that's only half of the equation, because if you don't have if you get the data up to the door of the SEC, but you can't open the door to look at what that data is, and you can't use it because you don't have the systems that allow you to analyze it or get your arms around it. What we've seen, and it's really incredible, and I'll just digress for a second, is that we have examiners in our exam program who, on their own initiative, because they've seen products or they've seen strategies out there that they think are important to understand, have developed basically their own software in order to be able to get their arms around it. And there's one program here out of Boston where an examiner developed an approach that has now been adopted on a national level that, was able to give an analytical capability to large amounts of data that the exam staff was collecting. I think that with the reforms that are taking place in our Office of Information Technology, incorporating them more into our programmatic interests so that they have a better understanding of the products that we regulate, of the firms that we regulate, is really key, because you can pass the regulation, but if you don't have the tools to deal with the information, then it doesn't really make that much of a difference.
Time for one more question, please.
First of all, thank you for coming here and for giving us this overview. I'd like to commend first as a comment, the work that SEC has done in the last several years. And just to confirm that, in just a few weeks ago in a conversation with Harry Markopoulos, he said SEC has become much better agency than what it was before, which I think really amplifies your work. So thank you for doing that for all of us. And
Mr. Markopoulos was, I think, very important in helping to change some of the cultural mindsets about how we receive complaints from members of the public.
right, and he also mentioned a few cases that he's working on, and of course, the question I have is about the insider trading rules for government officials and members of Congress. So if you can comment on that.
Sure. The Stock Act, I think it's Stop Trading on Congressional Knowledge Act, as I understand it. My unit has had a fair amount of involvement in providing technical input into the adoption of that legislation. You know, it's our position, or at least again, speaking for myself, my position, that the insider trading laws apply to members of Congress. I think that Rob Kazami, when he testified recently, took that position. We don't think that, you know, that there's an exclusion either for members of Congress or their staff or for other government officials who are under duty to keep information that they learn in their official capacity confidential. I think it's a good thing that they've clarified it, but I worry a little bit that, you know, because we think the rules already existed, that we don't want to create the idea that somehow the law that's been passed, I mean, while very good and helpful and important, you know, wasn't otherwise covered by existing law. I do think that, you know, it gets a little bit perilous when you tread into the world of legislative debate, and that's not my world really, but to the extent that I think that you know, the ways in which, I'll give an example, the ways in which policy and regulatory arbitrage are being conducted in the markets today, when somebody who has the ability to influence the outcome of things has the, you know, makes a comment, and you can trade in very high speed ways, that information can be acted on much more quickly. And I think that's an area that we're trying to get our arms around, is to, you know, when a member of Congress has information, you know, that might affect the interest of an industry or an issuer, you know, it's fundamental to our democracy that they be able to use that information. So to me, I think it's very interesting, but I'm going to stay away from commenting on whether it's a good thing or not.
All right, thank you very much. Don't go away. It would be a disservice to talk about fair dealing and trading and trust and honesty and that kind of thing, and have in the room a distinguished member of the faculty here at BU Law, Tamar Frankel, and not recognize her presence and her contribution of her body of work to this very subject over more decades than I will mention, Tamar. So thank you. In that regard, I'd like to start a tradition at our new center, if I might, if you'll bear with me. Dan mentioned when he stepped out of private practice because his desire to participate in public service. And it's become fashionable today to beat up on people like Dan and his colleagues, and I guess I'm as guilty as anybody else for doing that. But I think when we have a forum like this, it's a good time to remind ourselves of the tremendous debt that we owe to dedicated people such as Dan. And while I'm mentioning Dan, there are some of his colleagues here from the SEC. He mentioned Norm Nickel, and I'm not going to ask them to identify themselves, but I would like them to just stand up and be recognized for the job that they do, if you don't mind. There are a few of you. And Neil, could you remind me that that will be a part of all of our programs going forward? Any public servants that care to be recognized? Well, that said, there's a fine book by a gentleman by the name of Philip Howard, and it's called The Death of Common Sense. And it's how sometimes we create regulations and rules and lose the purpose of what we're about. So, for example, this is the point in the program where I would usually give some token of our appreciation to our distinguished speaker. But instead, I'm going to invite some of you to sign up for lunch. We're having a small lunch up on the 15th floor, and there's a sign up out in the lobby for those of you that can join us. Instead, what happens here is that, and this goes to your point about resources of the SEC being wanting, that lunch per person is going to cost about $15.71. And I am going to have to receive payment from Mr. Hawke in the amount of $15.71 for that lunch. All right? So what I've asked Lorraine from the law school to do is to get a picture of you presenting me with a check for $15.71, rather than me giving you a token of our appreciation.
I would be honored to do that.
Anyway.
Break 20, I'd be very happy.
Right. No, you're right. That's right. We're not charging you, but you're happy. We'd be happy if you leave your wallets behind. So anyway, I just wanted to say thank you again. And despite the fact that you walk away with nothing tangible from us, you do have our gratitude, and we hope you'll come back real soon.
It's my privilege to be.
Right. Thank you.